A recent top question we received is, how do you handle probate when minor children are involved? I'm 𝗣𝗿ecie 𝗯𝘁𝗲 of 𝗣𝗵𝗍𝗍 Law. I'm an estate planning attorney in New York and New Jersey, and we help folks achieve peace of mind by providing the utmost in value every day. Like today, we're here to educate everyone for free, so please ask us your questions and share so together we can help some folks along the way. At first, even if you have a trust as the core of your estate plan, if minor children are involved, the court gets involved. This is for the protection of the children. So if you're establishing an estate plan before we even get to the probate, and say a trust is the core of your plan, you should always have that backup will that may name your trust as a beneficiary, but it also provides names of guardians you would select to care for your children should something happen to you. Now, what does the court do? First, if there's a natural guardian, meaning a biological parent who already is a custodial parent of that minor, they will represent the child's interest unless the parent is also a beneficiary, which is commonly the case. Now, if the parent and the child both have an interest in the estate, the court will likely direct that a separate guardian be designated to represent the children's financial interests, okay? Because they have sort of a conflict between the parent and the child and their interests. Obviously, if it's a good parent, it's not a technical conflict or a real conflict, but it is a technical conflict in the eyes of the court. And so this is with regard to financial aspects only, as the custodial parent obviously is caring for their kids as little humans, right? So, but what happens if there is no custodial parent and they need to figure out who's going to care for the kids on a day-to-day basis, right? I don't know all the details of how they get placed temporarily. I'm assuming they do sort of a quick hearing to make sure they're in a safe location for them. But they will then turn to the suggested guardians that you've designated under your will, right? And they have to consider those first and consider those strongly because you've chosen them in the best interest of your children. But let's think about this, for instance. Imagine something happened to you, right? And you previously named your mom as the guardian of your kiddos because at the time she was 60-something, she was getting on the ground and playing with the kids, she was watching them 2 days a week. But fast forward 10 years and mom is no longer maybe physically capable and she's not the best fit to care for your children's needs at that point, right? This is why a court gets involved, so that they can consider the changed circumstances and the needs of your kids and figure out if your primary guardian, maybe your secondary, your alternate is a better fit. This is why, too, we always suggest having more than one individual in successive order, because time does have a way of slipping away and changing things, especially as, folks age and have their own concerns and issues. So we hope that you've learned something new here today. If you're in New York, New Jersey, and feel you need to reach out and have a conversation for free, you can find us at yourplanningattorney.com. That's yourplanningattorney.com. And we hope you choose to share. Take care.